Good morning, everyone. I know there's been a lot of crazy and negative immigration news, so I wanted to share a positive result that we got for our client this week, yesterday, actually. You can see February 18th, 2025 in removal proceedings. And this is something that I'm really proud of personally, and I'm proud of our team that worked really hard on this the last couple months. Because getting cancellation of removal for somebody who is detained, who only has one qualifying relative, who is aging out quickly and had a pending criminal case was definitely an uphill battle. And I'm not gonna say I didn't doubt myself or, my judgment in taking the case. But as you can see, our team's hard work paid off. We put lots of time and preparation into this. And so to give you some background on what happened here, this individual was detained by ICE after he was picked up on a county charge, not a conviction, for essentially unlawful restraint and like a battery type of a minor. Obviously, we completely denied the allegations. He didn't have his day in criminal court, but nonetheless, because he was charged, he was, picked up by county, and then ICE picked him up later when he was let out of the county system. So ICE picked him up. He didn't have a chance to defend his criminal case because he was detained by ICE. So unfortunately, the immigration judge didn't have any, not a not guilty verdict in the criminal case. It was just pending. And then he had really no relief available other than cancellation of removal, which requires that you've been here for at least 10 years, that you have good moral character, and that your removal to from the United States would result in extreme and unusual hardship to a qualifying relative. And in his case, he only had one qualifying relative who was his U.S. citizen child, age 20, turning 21 next month. And so your child, if they're a qualifying relative, needs to be under the age of 21. So we really had to, because they rely on you. So we really had an uphill battle here proving that his daughter was going to suffer extreme and unusual hardship. However, we provided a psychological examination. Her testimony was super compelling. She is very credible. Not only financial hardship, but emotional hardship. And we were also able to overcome, that pending criminal case. We had his criminal attorney on standby ready to testify if necessary. And again, we prepped this whole case while he was in detention, working with him over the phone, on his testimony, gathering the facts, getting his background. So it was a lot of work. And we chose to remain detained because his daughter was aging out. So if we'd asked for a bond in his case, because he was, I think, detained in October or November, picked up by ICE, we had a bond hearing scheduled, but we decided to forego that because if he was released on bond, he wouldn't get his individual hearing until maybe years down the line, at which point his daughter would have already turned 21. So we gambled here, we rolled the dice, and we decided, let's keep him detained. Let's get that individual hearing before his daughter turns 21. Let's put on the best case we have. This is going to be his best form of relief to beat this deportation. And so it was granted. Not only is he not being deported, he actually is going to be put on the list for a green card now. He's eligible for permanent residency. So I am super proud of this. I really am. There is still hope. There are still good judges out there who are following the law. And I just wanted to share this little bit of good news with you all for anybody who is in removal proceedings or might be detained right now and might have a similar case.